90.3 WHPC now presents Law You Should Know. The law affects every aspect of our lives, our home, our jobs, and our recreational activities. Now, learn about the law and how to protect yourself against the loss of your liberty or property, and learn how to stand up for your rights and seek compensation when you have been wronged. Your host for Law You Should Know is Attorney Kenneth J. Landau, a past dean of the Nassau Academy of Law, and frequently lectures to lawyers on ethics and avoiding problems with clients, and to the public on how to choose and use lawyers. This is Law You Should Know on the voice of Nassau Community College, 90.3 WHPC.
Hi, this is Ken Landau, and welcome to Law You Should Know. Today we're going to be talking about trademarks and how they are different from patents and other forms of intellectual property, and if you have an idea, what you can do to preserve it from day one, to hopefully make money and not be infringing on someone else's trademark. Our special guest for today is Attorney James Harrington, and he's with the firm of Hoffman and Barron, with offices on Long Island, New Jersey, and Washington, D.C. James, welcome back to Law You Should Know.
Hi, Ken.
I know your firm deals with all forms of intellectual property, including patents and trademarks and copyrights, and you've shared with us your insight on some prior shows which are available to our listeners at nccradio.org as podcasts. And today we're going to focus on trademarks. And so just tell us quickly, what is a trademark and how does it differ from patents and other ways of protecting an idea?
Yeah, well, I think, just more generally, we discuss, I think we discussed last time intellectual property in general, which is generally the value inherent in new technology, artistic and intellectual expression, and the goodwill developed in trade and commerce. And so those take, the intellectual property can take different forms, patents, trademark, copyright, trade secret. Today I think we indicated we would focus on trademarks, which differs from patents, which I think is what a lot of people think about when they think about intellectual property, where patents would be sort of a new idea or an invention that you would want to keep secret until you can get, that idea sort of put down in a patent application and on file. Trademarks differ.
So a patent might be an idea for a better mousetrap, and you want to keep it a secret until you're ready to launch and can get the details filed with the patent office.
Exactly.
So what would the trademark be?
The trademark would be a word, a design, some kind of logo that you would associate with that mousetrap in order for consumers to know that is your product. And so they can associate, that mousetrap, that particular mousetrap, with the source of where it's coming from. So
the trademark might be bugs will be DOA?
Right. Yeah. Or anything that you would want to, sort of put on the packaging in order for people to know, that's yours.
So give us some ideas of trademarks, ideas that people are familiar with.
Well, a lot of times, it's just a name. It could Exxon, Pepsi, Google, or
Kodak.
Or sort of arbitrary marks, trademarks, which are basically made up words.
And sometimes you run into trouble, like Xerox or something like that.
Yes, you could run into other people's trademarks, and I think I misspoke. The made up words are what they call fanciful trademarks. Those are words that didn't really exist before. I don't know if the word Google existed before, but it's a good example. When you say the word Google, everyone knows exactly what you're referring to just by saying that one word, and that's the sign of a really strong trademark. There's other words like Apple that are more what they call arbitrary trademarks. Those are words that already existed, but never before Apple computers were associated with Apple with computers.
And Apple has other meanings as well.
Exactly.
So you can protect the name Apple and the idea of Apple, even if it already exists in another form.
Right. Assuming that no one else is out there using it in the context of computers and phones and whatnot.
And if you think someone is using your name, so how do you register it? How do you become first in line to protect your trademark?
Well, the first thing to do in terms of trademarks, and it's another sort of distinction from patents where you might want to keep it secret before you file your application. Trademarks are different because the rights to a trademark come out of its use, right? So you want to make that as public as possible. You want people to know as much as you can that that logo or that word is associated with the goods or the services that you're providing. So you can put that out there before you file the application, and if that would be what we call a use application, where we're documenting the fact that you're using that particular word or logo in that particular way, associated with those particular goods or services.
And you want to prove that you used it, and maybe even a couple of times in different settings to prove it was out there. You're the first person to use it in public.
Yeah, I mean, what you could do, there are two different types of applications. There are use applications and there are intent to use applications. So if we file an application, a trademark application, and you're already using the trademark, we would identify that as part of the application. We would let the trademark office know when you started using that mark, and the goods. We would describe the goods or services, that would sort of encompass, your goods or services that you're using with that mark, and we would provide them that date. If you're not yet using the mark, but have a bona fide intention to do so, you can file that mark, and assuming there's no one else out there using it in that particular field, you can show your use later.
So this might be a clever word. It might be a slogan. Mm-hmm. It might be an interesting. Would it be a logo too?
Yeah, it could be a logo. One client we have is Boar's Head, right? People, associate, that's a very, famous mark that people, frankly, try to steal all the time.
And the name too,
right? Yeah, and they like, the way that it looks. I think a lot of people think it's kind of a cool thing, and it's associated with a high quality product.
And when you use it, do they use like a TM or something to show it's not just a name, it's a protected trademark?
Yeah, that's an interesting point. A lot of people kind of get confused between the TM and the R, right? So the TM you can use anytime that you feel that you're using that word or logo or design in order to identify your goods or services, that you're using it as a trademark, but it doesn't necessarily need to be registered. If you're using the R in the circle, then it needs to be registered with the federal.
So once you've registered
office.
It, and once it's been accepted for registration, then you can use an R.
Then you
put
can
everyone on notice. They can't just use this. It's a registered trademark, and it's meaning your company or your product or your slogan.
Correct.
The trademark is kind of like you intend to do that. You believe you've come up with the name first and you're intending it to be exclusive to you.
Exactly. The TM, you can put on there whether you've got an application pending or not, but the R shows everyone that it is registered.
Now, what if someone sees that and says, I had that idea a long time ago? What are their options?
Well, they could try to cancel your mark. There is a procedure called a cancellation procedure where they could go back to the trademark office and argue that, we were using that mark before they were, and therefore their federal registration should be canceled.
And they can also see someone like you who's an attorney concentrating in intellectual property and also patent and trademark.
Correct. Yep.
And sometimes you allow a use of it. There's licensing. There's all kinds of ways or maybe you agree or it can be used in certain contexts in certain places for certain purposes.
Exactly. That happens all the time. When we run into some of these trademark disputes, very often the goods or services are not identical, or the trademark itself may not be identical. And so very often we can, reach an agreement where, sort of you kind of stay in your lane and we'll stay in our lane in terms of, the goods or services on which it's going to be used, or on the mark itself. Just don't use this, particular word, or stay away from that particular, the way that it looks, and, we'll be okay.
And sometimes it's not as innocent, where someone wants to be the first. They realize it's out there and they want to be the first to file it, even if they weren't the first to create the idea.
Yeah, I mean, there's very often, there are, competitors out there, or people that you may not even really know about. And again, the Boar's Head mark is an example where, we police that mark, and we do find people that are essentially trying to trade off on the goodwill there.
And if someone has a mark or believes they were first in line, they don't have to begin expensive patent litigation, but they can go to a law firm like yours and send out a cease and desist letter, at least make them aware that they're potentially infringing on their idea.
Exactly. 9 times out of 10, that's all that it takes for them to just to let them know that we know what they're doing, and firmly ask them to stop.
And it puts them on notice for a liability and damages, even if you don't do anything right away.
Yes, we'll file that cease and desist letter, and if they continue, then a lawsuit may be necessary.
I just remind the listeners, we're talking with James Harrington. He's a partner with Hoffman and Barron. They're an intellectual property firm, which includes patents and trademarks and copyrights. And today we're focusing on trademarks and distinguishing them from other forms of property, and just letting everyone know how to protect your ideas, and how to be careful about not infringing on someone else's, which can have adverse economic consequences and lead to expensive litigation. If you missed any part of the show, please go to the podcast at nccradio.org, and there are other podcasts there about copyrights and other forms of intellectual property with our guest, James Harrington. And you're listening to us on WHPC 90.3 FM, the voice of Nassau Community College, and at the website nccradio.org in Garden City, New York. So, James, as we've been talking about, how else can someone expand on their idea for a trademark? What do they need full-blown to protect their idea? What are some of the steps involved?
Well, like I said, the first thing is to start using it. Start if you have a name or a logo or something that you want to use to identify the source of the goods or the services that you're providing with your company. Get out there and start using it. And then what we can do is we can file, if you want, we can file a trademark application in order to get that trademark registered, which provides a number of different advantages. It allows you to sue anywhere in the country. It allows you to sue in federal court, which very, very often has advantages. It identifies you as the owner. Very often, there's evidence that would normally be required to show you're the owner. Registration is essentially proof of that fact.
And it's a way anyone can find out that you are the owner because it's registered. It's if you're in different parts of the country, you may not known about it's being used somewhere else, possibly in a different context. But if it's registered, anyone who wants to protect something similar would do their due diligence and do some kind of check.
Yeah, and that's one of the main benefits also is the fact that when you do file your trademark application with the trademark office, that application will come up in their search, and not only on the trademark examiner's search, but anyone else that might be interested in finding out whether that trademark is already being used. It's a fairly easy thing to do on the trademark website.
And I guess what is the website, the trademark website?
Well, you could just go to uspto.gov.
Okay.
And then follow the prompts there. You'll see the different types of intellectual property that they deal with, mainly patents and trademarks. So you can click on the trademark link and then follow it from there. But there is a search link that's fairly easy to use.
And I guess you could try Google in case there's something else on Google.
Well, yeah, that's a good point because the trademark examiner will very often just search the trademark office, right? But if you really want to know whether that mark is free to be used without infringing on anyone else's rights, you would need to look, do a Google search and see what else may be out there that isn't necessarily registered but could still be a problem.
And if if you want to try to protect the idea and be first in line, you should start using it as well, even before you've done anything informally. So put it on your business card, put it on your web page, put it on your LinkedIn, put it in your correspondence.
Yeah, exactly. And sometimes people get, a little nervous, understandably, about making too big of an investment in the marketing materials without knowing whether, they're ultimately really going to be able to use that mark, or whether someone else already has it and it's going to become a problem. So sometimes even before they really make too much of an investment, they'll come to us. We can do that type of search for them and let them know whether we think it's going to be registrable or whether they should think about using something else.
And what happens when it's similar to something else? What's sufficient differentiation so that you can have your mark and someone else can have their mark, as you said before, in different lanes?
Yeah, in general,
or perhaps different highways.
Right. In general, the standard is whether it would be confusingly similar to a consumer. So if even if the goods or the services are not exactly the same, but or the mark is not exactly the same, if they're close enough where people are going to start getting confused as to the source of those goods or services, then it's a problem.
So sometimes there are some businesses which are, let's say, in different lanes, and they can use the same name and there'll be no confusion.
Yeah. I think, a well-known example is Lexus and Lexus, right? There's Lexus the car, there's Lexus the, legal computer, research.
And probably most of the general public is not even aware of the Lexus research or the computer, except lawyers or business people who have to deal with that.
Exactly. So that's an example of two marks that, peacefully coexist without much trouble.
And if you were going to have Lexus in the Lexus, then there can be a problem.
Right. And
you've described some of the ways to protect your trademark, to protect your ideas. Are there any others?
Yeah, generally, I think that's what would need to be done. I mean, you need to use it. A search is advisable to make sure you're not stepping on anyone else's toes. And then, if it looks like it's it's something that would be beneficial to your business in terms of people associating those goods or services with your company, I think it's a good thing to get that registered, and we can do that, fairly easily.
So it's use it or lose it, and then register as soon as you can. And this is more about a name or a concept or a marketing slogan. It's not about a business plan or a business concept.
Exactly. It's not an invention. It's not a new idea. It's something, word, logo, design that is associated with the goods and services and allows people to know that it's coming from your business, which you've made an invest in development.
And what if someone follows your advice and they register it? How much protection does registration provide? Well, what's the scope of the registration?
Yeah,
the scope of the protection.
Yeah, we touched on it earlier. The main benefit is if you don't register and you're just using the mark in association with your goods and services, you can still have common law rights without the registration, but those rights are limited geographically to just essentially where you're doing business. If you register that mark. You can go after anyone in the country, regardless of where they are. If you know that they're using that mark in your sort of sphere that you've described in your goods and services, you could go after them.
And that description of goods and services, you want to make it as broad as possible so to preserve your future rights.
Yes and no. That's another important distinction between patents and trademarks. With patents, we want those patent claims to be as broad as possible in order to capture as many infringers as possible and sort of set that fence as wide as we can within reason, based on what's out there in the prior art. With trademarks, we could be a little bit more judicious in terms of how we describe those goods and services, because you don't want to go beyond the goods and services that you're actually using, right? If you do that, that can cause a problem. Because you're declaring that that those are in fact the goods and or services that you're using that mark in connection with. If that turns out to not be true, there could be a problem with your registration. So you want that to be accurate.
And just briefly, how long does that protection last?
It could last forever. As long as you're using that trademark in connection with those goods or services, after 5 years, you're required to file a declaration saying, yes, you're still using that mark in connection with those goods. And if it's been sort of on a consistent basis, you can file another declaration requesting incontestability. And then after that, at the 9 to 10 year mark, there's the renewal. And every 10 years after, it can be renewed as long as you can, again, declare that you are, in fact, still using that mark in association with those goods or services. So it could last forever.
Okay. And in a moment, we're going to discuss about if you can protect it in a foreign country and if you can license it and other ways it might help your business. I just want to remind our listeners, we're talking with James Harrington. He's a partner at the intellectual property firm of Hoffman and Barron with offices on Long Island, in New Jersey, and in Washington, D.C., and they concentrate on patents, trademarks, and copyrights and other forms of intellectual property. You're listening to Law You Should Know. His insight about today's topic, trademarks, and his prior programs about patents and copyrights are available as podcasts here on WHPC 90.3 FM at nccradio.org. And Jim, if someone they protect their trademark in the U.S., what can they do about protecting it in foreign countries?
Yeah, again, some countries require that you actually use, like the U.S., use the mark in connection with the goods or services. Many countries don't. So very often what you could do is you could sort of take that logo or word or whatever it is you're using and then try to obtain protection in other countries that you think you may be selling. Obviously I wouldn't waste, the investment in filing on countries where you're never going to be doing business. But if you do think that your products or services will wind up in a particular country, you may want to consider getting trademark protection in that country. And so we can do that. We have other intellectual property law firms in other countries that we work with. Very often we have a reciprocal relationship, and we can contact them and have them file a trademark application on your behalf.
And let's talk about a logo. So what is the exact definition of a logo?
Usually a logo is sort of a picture or a design. The Nike swoosh would be a very, obvious example where it's not a word. We kind of make a distinction between word marks, which, as the name indicates, is just a word, and sort of a picture or a design, that would be more what we would call a logo.
And it's associated with your business or the nature of your business?
Yeah, that's the key. That's the key to the whole thing in terms of trademarks. It's sort of making that connection so that, again, sort of using the Nike swoosh, right? Once people see that, right away they associate that product with a certain image, a certain level of quality,
and a certain business,
and they know and the source of that business, where that product is coming from.
So the McDonald's arches would be another example of that.
Yep.
Now, can you use your initials or use it in some way showing what you do? Just a car crash with your initials or in some kind of design or.
Yeah, I mean that's
for us lawyers out there.
Yeah, that's one area where people get a little bit into trouble if they try to make the trademark too descriptive. That could be a reason for the trademark examiner to reject the application. So a lot of times people will think, well, if I kind of sort of come up with a name that indicates what it is I'm doing, that would be a good trademark. Very often it's the opposite. It's something that's just a made-up word or a word that has no association at all that really gives the trademark its strength.
But if for your own business, whether you're a law firm, accounting, or something else, you can play with the name and play with what you do. Mm-hmm. You just can't protect it. Yeah,
you can always put out a name or a word or a design, again, assuming it doesn't infringe on anyone else's rights. But you could use those things with your business. The only thing, like I said, if it's too descriptive, very often the trademark examiner will say, well, that's a reason why we're not going to give you federal registration.
Okay. And just to recap, so you have to use it or lose it and spread the word and prove that you used it.
Mm-hmm.
And just give us your website again for someone who wants information about any of these areas of intellectual property. Yeah,
you can find us at hbiplaw.com.
And there'll be a lot of useful information there.
Absolutely.
And the website for the patent office again, the trademarks.
Yeah, is you can just generally go to uspto.gov.
Okay, so if you have an idea, it's good to consult with a lawyer, do a little research if you want, or get an idea how you can do your own research, and protect your idea if you can.
Yeah, and again, I think another important distinction between patents and trademark applications is trademark applications are much less expensive. When you're working with an inventor and you're trying to describe in words and pictures a completely new idea, that's very, very time consuming
and technical.
Right? Trademarks obviously are much less technical. They take much less time, so we can get a trademark application on file, really, without much expense.
And in order to get to be accepted again, because we've discussed a lot of different scenarios, how does it have to be unique, and what's necessary to protect that idea?
Well, we would need to know exactly what it is you're using, right? Because we don't want to file a trademark on a moving target, right? So you want to sort of be locked in. And then we would file that application. We would need to know the word or logo, specifically the final version of what you're going to use.
So your slogan or word.
Right. Okay. And we need an accurate description on the goods or services on which, that trademark is being used.
And what it means.
Mm-hmm.
Okay. I would like to thank our guest, James Harrington, with the firm of Hoffman and Barron, for being our guest. If you missed any part of the show or you want to tell someone else about it, please just go to our website, nccradio.org. And as I mentioned, there were podcasts there of other shows with James Harrington about copyrights and other forms of intellectual property. It's very important to protect your ideas. And please join us next week at this same time for another program on Law You Should Know on 90.3 WHPC, the voice of Nassau Community College in Garden City, New York.